We often assume arranging our finances to pay the lowest possible tax is illegal. It feels like navigating a loophole, like cheating the system. But under Belgian law, tax optimization is a strictly recognized legal right. You are absolutely not obligated to choose the most heavily taxed route for your income. The Belgian copyright tax regime is highly advantageous, allowing certain intellectual property revenues to be taxed at a mere 15%. Naturally, a benefit that attractive draws two very different crowds: genuine creators looking to monetize their actual work, and opportunistic actors searching for a cheap tax disguise. So if optimization itself is perfectly legal, how does the state separate the legitimate, smart creator from the blatant tax abuser? This dividing line measures the distance between economic reality and legal fiction. When crossing that line into fiction, you generally fall into one of two distinct legal traps. The first of these is called simulation. Simulation occurs when the setup is entirely fake. Your paperwork claims a copyright transfer, but if we peel back the label, the reality is a standard service. The state strips away this facade and taxes the underlying reality at the standard higher rate. The second trap is a bit more complex. It's known as fiscal abuse under Article 344 of the Tax Code. Unlike simulation, fiscal abuse happens when the contract and the creation are technically real. A piece of work was actually made, and a contract was legitimately signed. However, the entire corporate structure was set up for the exclusive purpose of dodging taxes, lacking any other commercial logic. This violates the explicit intent of the copyright law. The regime was designed by the legislature to reward genuine creation and protect authors. It was never meant to serve as an empty vessel for tax evasion. So, what happens when the tax administration decides to investigate your copyright claim? You enter what is effectively a duel of proofs. During an audit, the burden of proof doesn't fall entirely on you, nor does it fall entirely on the government. It is legally shared. Looking at this internal tax administration document, we see how they approach audits. The state moves first, demonstrating your setup is a tax avoidance scheme. If they do, you must prove genuine, non-tax motives, defending specific axes of control, like whether the work is actually exploited. Surviving a tax audit, then, requires proactive, documented evidence. It shifts the focus away from abstract legal theory and straight into the practical need for hard proof of your commercial intent. The ultimate insurance policy for winning this duel of proofs comes down to a single concept: economic substance. Economic substance means three specific things. The creative work has actual value on the open market. The contracts reflect real exploitation, and there is a genuine economic reality to the rights you are licensing. A clever contract phrase or a smarter loophole won't stop an anti-abuse audit. Only a thoroughly documented reality provides a definitive defense. If the creation is real and the economic substance of its use is heavily documented, your tax optimization is perfectly safe and entirely legal. Please note, the information provided in this video is for educational and informational purposes only and constitutes legal information, not legal or tax advice. Always consult with a qualified professional regarding your specific situation.